Okie dokie. So, alrighty. So we're recording now.
Thank you for doing it.
Okay, Dave, how you doing?
Yeah, I've had a challenging week, as you know. Yeah, I'm good.
All good.
All right, so I've got a court case on Thursday. This is with a credit card company called Finstro, and their lawyers are called SLF lawyers, who are taking me to court for non-payment. However, payment has been made through bill of exchange. Let me just shut this door, Michael, because I can hear the planes coming over. Just give me 1 second. That's better. Yeah, so I've sent a bill of exchange across to them. They refused that as a form of payment. I then sent them up the follow-up letters that we have on LIP and everything. And now, long story short, we've got a court case coming up on Thursday.
Now, you're in Australia or in England?
No, in Australia, mate.
You're in Australia, yeah. Okay.
Yeah.
There is a court case, which basically it's just that's what the whole claim or the court case is about, is that one party's saying that the other party didn't pay. Right? Now, first of all, when you present yourself in there, you just let them waffle their rubbish. Acknowledge yourself as David, of the house, and just don't make a big emphasis of it. Just get it on the record. You're David of the house. You're the general executor of the account that's been with the in the name of the person. All right, and then just let them waffle. They'll come round to you first anyway. They'll want to probably ask you, do you understand why you're here? They don't understand. I'm not the surety for the bill. A bill of exchange was processed on it in my capacity as the general executor, and it's been settled, and it should have been discharged by the other party. So the fact that they haven't done it is beyond me. And then they'll start going on and carrying on like 2 bob watches and stuff like that. Right? Now, the moment they raise the issue, you need to get them to acknowledge that they received the bill of exchange. And how you do that is using forensic questions. For example, you get them to bring up the issue of, have they received the mail? Right? Did you open the mail? Did you pull the bill out and read it? Was there a bill of exchange written on it, a signature written on it? The moment they go yes, yes, yes to all those things, it's done. There's nothing. There's no turning back. All right? Because if you quote at the Australian Bill of Exchange Act 1909, Section 48, it says virtually the same thing as UCC 3-603, and it basically says non-acceptance is discharge. All you've got to do is get them to say on the court record that they received the letter, that they acknowledge they have received the letter, basically, that they read it, they pulled the letter out, and they read it, and then they acknowledge that there was some words written on there in the form of an endorsement with paid in full with a signature and a date, right? So that's a bill of exchange. When they say yes, 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 say, well, I don't know what the problem is then.
I've got an email trail of them stating that they don't accept the bill of exchange. So I also sent it recorded delivery, so I actually have a tracking number also as well. So now the lawyers, it's the lawyers that will be in court that are representing the credit card company. So they won't have actually.
Lawyers are knuckleheads, right? This is not something that comes across their desk every day. So their standard is, no, he didn't pay. He didn't pay. The only method of payment is going to be check, credit card. It was stated on the bill. All you've got to do is turn that around and say, but they're all forms of bills of exchange, aren't they, Your Honour? You involve the magistrate into the conversation. You make him hold the law. Sooner or later, that magistrate's going to come onto your side, and he's not going to throw himself under the bus with the prosecution. but there is plenty of case law precedent in regards to bills of exchange gone through in the Australian courts. Right? The best one is the one that I had in the BOE. I'll just try and look it up while we're talking.
Is it in LIP?
Really, don't deter. Sorry, what was it?
Is it in LIP?
So yeah, I found the list of a number of them. Yeah, so it's the Commercial Bank of Australia versus Amadio, 1983. Have you seen that one at all?
No.
What I'll do is I'll forward that to you
into
your private message.
I mean, if a precedent's already been set in court, then that's good, isn't it? All right, I got that now. Thank you. Cheers. So
and then there's some more here as well. So
my tactics, Michael, is I want to say as little as possible.
Yep.
So look, I've wrote down some notes
here.
I've got some of these from.
So the claim is the bill hasn't been paid.
Yeah.
Their claim is you didn't pay. You didn't pay. Objection. Who's you? My name is David of the House Wildman. I'm not the name summoned. Okay? You are the general executor of that account. It's an account. It's not you and it's not your name. So when they speak as if it's you didn't pay, what they're doing is, in their own language, is making you claim it. You get me?
Yeah. All right. Like I said,
okay.
I want to try and say as little as possible. So I've wrote down some notes, which I have taken from a couple of conversations that you've had with other people. Okay. So I'm here under duress. And as one of the administrators, I have an intent in this matter. This matter has been, I can't even read my own writing here, has been, what does it say? And chime in if you want, if I'm getting it wrong. This matter has been, I can't even read what that says, and I do not understand why I'm here as the ones who has not they as in Finstro are the ones that have not fulfilled their obligations, fiduciary duty, after basically, denying that they have to receive a bill of exchange. I have emailed them, asking them for evidence as to why they don't have, why they don't accept bill of exchanges. And I sent it to you a couple of weeks ago. I think you got it. And I also got a Freedom of Information request asking for documentation as to why, documentation if it exists, that government institutions, banking institutions can, deny a bill of exchange, which obviously that documentation doesn't exist. So I have that also as well. Now, should I bring in email conversations? Should I bring in my bill of exchange, all the converse that I've wrote to them? Should I bring
you hit the nail on the head before. If that script of yours, if that's what you plan to actually say in court, you're waffling too much.
Yeah, okay.
In your head, you're under duress. That's why you're there. The judge will probably ask, why are you there then? Why are you under duress? This matter's been remedied months ago. A BOE was a BOE endorsement. You must speak the words. A BOE is just general. A BOE endorsement was made on the bill and returned to the drawer. What the drawer has done with that, Your Honour, I don't know. It's not my problem.
Yeah. I'm also under duress because in the letter that I've got from them, which asked me to go to court, it says a threat of arrest if I don't turn up. which I don't see is
Yeah.
really the case, because it's a civil case, isn't it? So can you be arrested under a civil case of turning up to court? Do I
It's their
have
court
an
system.
obligation
It's their bullshit.
to go?
It's not else. It's not common law. It's their bullshit, mate. You're on a ship. No one has an obligation to go. The problem is they send their thugs around.
Yeah. But can they send their thugs around for a civil case? Because no law.
Mate, they can do anything they want.
Right.
They can do anything they want. They don't follow the law, mate. They follow their own bullshit. That's how bad it's got.
Yeah.
They're not following law. They're following rules. There's a rule of law, which is Royal Crown assented acts and laws, and then there is what they call laws and rubbish. There's actually policies. They're corporate policies. They've got nothing to do with law. And corporate policies only apply to employees of that corporation and slaves.
Yeah.
And we're neither. We're subjects of the Commonwealth. Whether they like that or not, it's irrelevant. But you're going in over a payment issue. Stay on point. Stay on that payment issue. Their argument is you didn't pay. Now, those 3 words is quite broad. What you need to do now is break that down so that you have full disclosure, right? Because you don't understand why you've been forced against your will to attend an administration for a name that was summoned that ain't yours. You getting it?
Yeah.
And then how I'm talking to you is how I would explain it on the court record. I couldn't give a shit if the judge heard it or not. It's on the court record. Once it's on the court record, it means the court heard it, which means now the magistrate's got 2 choices. He can fob you off and talk like you're talking nonsense and use that as an excuse, or he starts to rethink about his position in the whole picture because he's either on your side or on theirs. He's going to have to take sides.
Well, we know which side he's going to take, don't we?
Well, initially, yes. But when you challenge what the prosecution has to say, you're doing it in favour of the magistrate. You want the magistrate to confirm what you are saying so that more and more he has to climb over your side of the fence because he can see that the prosecution is just about to die and be held accountable. You understand?
Well,
he ain't going to throw himself to the mercy of you along with the prosecution.
So you made the point.
You made
the point a couple of minutes ago about involving him or her, whoever it may be. So, I mean, I plan on saying this because you can't really deny this. Like, Your Honour, that in Australia, the Bill of Exchange / promissory note, being a royal assented act, is still in this country. So therefore, Finstro, which is the credit card company, are not immune or exempt from acknowledged bills of exchange. Is that right, Your Honour? So
yeah, you're right, but you keep defending. Don't defend.
Okay.
Right? You don't need to prove how smart you are knowing that piece of set. It's not about that. It's purely about the other side making claims you didn't pay. So what you got to do, depending on how they make their claim, what they actually comes out of their mouth, that's what you have to jump on. And that's with objection, and then you wait your turn. After the plaintiff has had his say, the magistrate will ask you, okay, so what's your objection in regards to what the plaintiff has just said? You just stick to that. And you start forensically pulling it apart. His claim was you didn't pay such and such. We've had a number of letters out to the client, to Mr. So and so. You know, first of all, who's Mr. So and so? Is that a person? They'll probably say yes, it is. So it's a fiction, property of the state government. It's the same name that was summoned here today. So why am I forced to be here?
So when you say break it down, I'd just basically say objection, and then the judge will say objection under what grounds, and I'll say the debt has been settled via bill of exchange. Here's the original. Here's the bill, and that's it. Yeah.
It's just made false claim. Put it on the record. The plaintiff has made false claim. And he'll say, well, what's false about it? You see, just little is more. The plaintiff has made false claim. Then you wait to be asked because you don't know what they're thinking. You understand? They're creating the path. You don't know what path they're taking. So when they're creating the path, you stay on path with them, but you ask them in a question, whatever they said, you focus on that particular, nothing else. Don't change the subject.
So if I say, Your Honour, the debt's been settled, it's been settled by a bill of exchange, here's the original, or here is the bill.
A bill of exchange endorsement. The cheque was sent. Remember, use the words that are printed in the bills of exchange. Don't use common English. I know what you mean when you say it.
Yeah.
But it's not the same in a court, mate.
Okay.
Be very articulate. Be very forensically, very specific. A bill of exchange check. A bill of exchange bill that was received was signed, endorsed, and that check was sent back to the sender.
It wasn't
then
sent
you
back.
Sit down.
They've still got it.
It's irrelevant. Yeah, that's right. But that's irrelevant. We're talking in court right now. Don't voice what your thought is. We all know this, right? We're talking about your day in court. Just focus what's going to happen in court. The word, what may just be used. It's hard to script anything because every judge is different.
Yeah.
Your plaintiff is different. You know, you could, over the same bill issue, another plaintiff would have cashed it in and left you alone. These people have created a controversy. See, the word. The plaintiff has created a controversy, Your Honour. It's been remedied 3 months ago when the bill was received. Don't say I received it. Remember, the name. You can't join to the name. Right? The bill was received. I personally wrote on it as the general executor of that account name, and then I posted it back, that check, and then a few weeks later, the plaintiff's client responded with acknowledging they have received it, but they're not accepting it, Your Honour. Then you sit down, right? You sit down and you be quiet. You let the magistrate figure it out in his head, because if he knows the bills of exchange, he would know straight away, oh, UCC 3603 applies here. Oh, the bills of exchange. It's not your job to educate them, mate. It's just your job to speak fact. Only speak facts. Don't hearsay, presumption. Tell only the fact. And the fact is, forensically, step by step, what you did as the general executor, posted it back as a check because you've endorsed it. Isn't that right, Your Honour? A bill of exchange that's endorsed is now a check. When I post that back to them, they got paid, right, Your Honour?
What are the chances of the judge being plain absolute ignorant to a bill of exchange and him or her saying, "What's a bill of exchange?"
It doesn't matter.
They're on their side, aren't they? So they're gonna, they're not gonna make it easy for me. I'm well aware. So if a judge says, "What's a bill of exchange?"
That's a presumption. It's a magistrate court, clown school. Magistrate courts and district courts, they're all clown school. You're going to end up with the worst of the incompetence in law. It's only in the Supreme Court you will win, because if you note those case law precedents, they were all done in the Supreme Court. So each of those cases would have started off in a magistrate, then did an appeal into the district court, and then had to do an appeal in the district court straight into the Supreme Court, and then the whole thing got turned over.
Yeah.
You have that right. So you might be lucky and a magistrate's cotton on to all this. He's probably seen cases prior to this and thought there's no way the plaintiff can win because you were right. When you put on the court of record, you're the general executor. You did due diligence as one of the admits. You wrote on it in blue wet ink. You signed it. You dated it. And you returned it back to the drawer who non-accepted 3 weeks later. So that's proof they received it, Your Honour. Therefore, under Rules of Exchange Act, Section 48, and UCC 3-603, it's discharged. Isn't that correct, Your Honour? You see, you're making the magistrate your buddy.
Yeah. Yeah.
Need him. You need him. Because you're not allowed to talk to the prosecutor direct, right? The plaintiff direct. So you have to speak through the magistrate back to them. So when you talk, make the magistrate your friend. You're clearly stating you just want confirmation. The job of a magistrate is to be non-biased.
Yeah, okay.
So the moment he does a biased thing, you call him out. Say, "Oh, excuse me, what do you mean by that? I don't understand." Because the law states, which your claim is contrary to rule of law. See, another beauty cherry in the court record. And they're very short questions. They're not long, brief, full paragraph things that you're reading. And just tell it as it is and only stay on point with what they're saying. I can't help you exactly what to say because, well, it doesn't matter how much you read and how much you memorize in a script. It's always going to end up different in the court. So don't get hung up on trying to remember a script. You must know your position.
Yeah.
You must use the words that distinguish you different to the name summoned. The name summoned is just an account. It's a name of account. That's it. Don't talk like it's you. Don't let them talk like it's you.
Yeah, okay. Well, look, like I said, I'm going to try and stay as least as I possibly can and just sort of stick to what you're saying, so... All right, okay.
So what you can do is you like perverting justice. If he does not, if you get what we've just been saying, what I've just been saying, you've got all that out on the court record, and that magistrate, numbnut, is still talking nonsense, then you start questioning his judicial authority. You start questioning, are you okay, magistrate? Are you suffering from mental health? Do you not recognise the 15 rule of law and the nonsense the plaintiff is putting out?
Would you bring the...
You call it out.
So the Bill of Exchange Act, which I've got, it's like 72 pages, but should I print that off and bring it with me?
Well, you can as something to refer to should you need it, because he may ask you if you say, oh, Bill of Exchange Act Section 48, and you just leave it at that. He's going to say, oh, I'm not familiar with that section. What does that mean? He's testing you.
Yeah, well, there's on LIP.
He's testing to see if he can throw you under the.
So on LIP under the Bill of Exchange, there's like main parts of it that we can use in our favour. So I can download that off and I'll take those with me. And
take UCC3 with you as well.
Yeah, that's on LIP
because it is a UCC court.
Yeah.
It is a UCC court.
Yeah.
Not a Commonwealth court. The Bill of Exchange is a royal assented Commonwealth Act. And they may choose to accept it or not because it's not within their jurisdiction. You understand?
Yeah.
Because they're maritime, right? They are operating under UCC. So what you do is take the UCC one, because it says different sections there tell you if it's been delivered. Tells you, the sections tell you how to deliver a bill, how to write on a bill, what the 5 points of information must be on the bill, which is the name, the address, the name of the drawer, the name of the endorsee, the endorser, the account number, the dollar amount, and the signature. They're the 5 points of a BOE. And if all those 5 points are on there, there's no reason they couldn't accept your bill of exchange, because it is the only legal tender in this country.
So all contract law that they use, like governments, banks, it's all under the UCC, isn't it?
Yes.
Yeah. All right. Well, that's very, very
UCC.
Enough said then.
The UCC 3 is the Article 3 is about billing. So how to bill, how to draft a bill, what information needs to be on a bill, how to date a bill, how to due date, the reason there's a due date, the reason that has to be settled before, what happens if it's not paid. There's so many terms and conditions with a bill of exchange. You have to follow within the parameters where you come out the winner, purely because you start with the paperwork. You've done everything in your power to ensure that your UCC3 is appropriate. It's not hard. They send you a bill. All the information is on there. All you got to do is put a signature on it and send it back. It's as simple as that. It's a check. It's a blank check being posted to you, and your proper conduct is to put a signature on that and send it back, and it's discharged. What happens after that? It's not your problem. It's theirs. If they don't accept it, they have created a controversy. If they send you a bill and you do exactly the same thing again, you put a BOE on it, you turn it back, didn't you just establish if there was a purported default, you cured it with the second one, right?
So
now, when they come back with another stupid letter saying, I told you, so long as you have the path, so long as you have your bells and whistles all checked in place, you're only turning up to confirm that the matter's settled as far as you're concerned. The plaintiff is complaining about something that they've already received and refused to discharge. They refused to cash it in. Yeah. It's legal tender. It's money with your signature. You can say that. It could be a cross question. Isn't a signature on a bill a check, Your Honour? He's going to say, yeah. I've asked many lawyers, what's a BOE? And the first thing that comes out of their mouth is, it's a check.
Right.
So the magistrate's going to call it, yes, it's a check. I said, great, Your Honour, thank you. I moved the court to discharge, because what did he do? The magistrate just agreed with you. He received a check, signed. There's nothing more to talk about.
Yeah.
And you may You may not even have to go through the whole rubbish with, there's case law precedent. You may not even need any of that stuff if you know how to navigate through quickly. Then all you're getting them to do is acknowledge what you just did. And if you get the magistrate to agree with you, the case is done.
Yeah.
You just order the court. I order the court to dismiss this matter, because on the court record it's been established that they received my cheque, signed and all.
Yeah. Okay.
So they can't say they didn't pay it. Don't get in too much in the detail, but when you're talking, make sure you're very clear. It's a cheque. Isn't that right, Your Honour? He's not going to say no. He might try and change the subject because he doesn't want to be involved in this because he knows where it's going. So what you do is, Your Honour, before you can move forward, that doesn't matter. You've got it on the court record. You only have to repeat it 3 times and it's done. Don't let yourself get sidetracked. You're stating facts, Your Honour. I'm stating facts. Their presumption is it hasn't been paid. The fact is they acknowledge they received the bill back signed with the proper signature.
Yeah.
And that would be a cheque, a signed cheque. Isn't that right, Your Honour?
Okay. All right. So that's one thing. The other thing is about what happened on Thursday with the car. So I've
okay. You have grounds to sue the folks that took the car because you have no contract. They might use the excuse, oh yeah, but the police told us. Don't give a shit who the police are, mate. You don't have a contract with them
just
either.
repeat that again, Michael. It froze. Sorry.
Towies can't just come onto your property and take your car.
But it wasn't on my property. It was where I work. My work is really close to a council car park, so I parked my car in there, and
they must follow you.
Well, no, I don't think so because it was about 4 o'clock. So there must be maybe a tracker in the car or something like that. Maybe I don't know. I did think that.
It's possible these days. All these new cars have these trackers in them.
Yeah. So, does it make a difference the fact that they've taken the car from a public car park as opposed to my residential address? My private.
No, if it's in a public space, then it's there's nothing you can really do. The only trespass they've done is actually steal your property. What you have to be able to determine is it actually your property? Question I'd be asking first is, who's it registered with? The government or with Royal Registry?
It's both. It's registered. It didn't have Royal Registry plates on it, but it's the rego runs out with Revenue New South Wales, I think, in March. But I do have a certificate of the car from the Royal Registry.
Yeah, your certificate from the Royal Registry is not going to help you. You registered it with GovCorp and you have GovCorp plates.
Right.
It wouldn't be registered with GovCorp if you cancelled the plates and handed the plates back. Then it's removed from their system. Now, the only registration recorded against that piece of property is with the Royal Registry. So it is registered. It's just not with GovCorp. So it's not lost cargo. So in a public place, no one can come along and just take it like the towies did because it was registered. But in your case, those towies were instructed by whoever to go and collect that car. Right? Now, if you've done a bill of exchange on the finance or whatever's on that, then yes, they may still come and take the car, but that's a no-no.
Well, that's what.
Now you have counterclaim.
Now I have what? Sorry.
Counterclaim.
Right. So I've put a litigation request in. Spiros got back to me on Friday, just asking me what happened. And the last I've heard from him was from last night, just saying who was it that took the car. And I gave him the name of the company that took the car, which were able to cover his I can't remember what the company was called, but they were acting on behalf of the people that I bill of exchanged.
Yep. That's fine. What'll happen is, and I'm guessing, I don't know what plan exactly the registry will do, but from my experience, it's pretty straightforward, really. It's really just, rather than take them all to court and sue their ass, it could be just as simple as sending a letter from someone like Spiros, who has the legal knowledge, and sending a letter to them and pointing out the error in their ways, because bill of exchange is bill of exchange, whether they like it or not. I've had this argument with lawyers face to face. They say they know what bills of exchange is, but they really don't know. They didn't know, or if they did, they're not sharing that. They play dumb. Is that all they had to do was sign a bill and send it back? It's as simple as that. They didn't. And now, I had one lawyer say to me, like, I wish I got $1 for everything that was said, was, well, if you don't pay your bills, how do roads get repaired? How does this stuff? This all nonsense shit, I think, and I'm just looking at him thinking, are you for real? And you're a bar member. All that schooling gone to waste. That certificate you got is a waste of bloody time, mate. You haven't learned anything.
So that letter that you sent to me on Thursday night about, I sent it to them about them returning the property, and obviously I think I sent that to them Friday morning, and they've not responded to that, so.
That's good. If they haven't responded, that's another bullet in the barrel, right? And that you may not have to, when you go to court, may not have to make it an issue, not even have to raise that issue. But should you need to, it's there to use as evidence. We're talking prima facie facts. These knuckleheads that keep calling people into court don't have facts.
So you think,
so long as you follow the bill of...
So you think it could be as easy as Spiros just writing them a letter, basically?
Possibly.
Yeah. Okay. All right.
He may. Yeah, you just make a small contribution for his time to draft the letter and do something for you. It may not be a court case.
Yeah.
We do a lot of those, believe it or not, in between our civil claims. Some of these litigations we get, that's a quick fix. It's just a letter.
So if it does go,
and we're more than happy to help and assist with it.
So if they just think, I mean, look, they've ignored all my letters in regards. So once I sent them a bill of exchange, they obviously denied the bill of exchange, and I sent up a follow up letter, which is on the on the LIP system and everything, and they've just denied it or ignored it. So let's just say they just ignore Spiros's letter, and then I guess what we've got to do, give them 14, 28 days or whatever. So then it gets to early next year.
Well, that's a civil, but that's a civil claim for damages now.
Yeah.
If they ignore the letter, that's now a claim for damages.
They're likely to then just put that car on auction, so the car's going to go. But let's just say, like, we then make a civil claim against them, and it goes to court. Let's just say in March, April, and Spiros takes the case on or whatever, and we win. Are we going to be compensated for the loss of the car, or like what will happen?
Well, I believe you should be, because your bill of exchange paid it.
Yeah.
The finance company has no claim on the vehicle. It's been discharged. The debt, there is none.
Yeah.
So if they come along and just take the car, and their argument is you didn't pay, but at the same time they're saying we received your bill of exchange, but we're not accepting it. Well, then they have to refund you the full value of the vehicle, because you're out of pocket of a car, aren't you? And you need to replace that car. So whether they burn that car, crush that car, don't really care. They have to compensate you, plus the stress, heartache, and all that sort of stuff that goes along with it. There has to be plus something,
Yeah. I mean, look, when it happened, I was like, fucking hell, But now that I've had time to reflect and time to calm down, this could be it could be a massive win for us in our community, because if people, obviously this has happened now, and like let's just say like in 4, 5, 6 months time or whatever, that I am compensated, and I mean word gets round, doesn't it? So this could be massive for us, So I've got to see it like that.
What's annoying for me is you've got 100 people sitting back waiting to see what happens to you. So you're going through the ringer. You are copping all the punches and bruises and everything because the 100 cowards sitting back watching. If the 100 cowards actually got up and acted like a bloody full-grown adult, competent enough to handle their own bloody life and their rights and everything else, these insurance companies wouldn't be stealing people's cars full stop. 100 people doing exactly what you're doing makes a huge difference.
Which 100 people are you referring to? Like in the Royal Registry, you mean?
It's in general. It's a general.
Oh, okay, right, yeah.
Look,
all right.
You've got what, 1,000 of us doing this. There should be 100,000 people around Australia doing it.
Yeah.
And we have 3 million sitting back watching. Oh, we'll wait and see what happens to you.
Oh, okay, I see what you mean. Yeah, so yeah, so the 3 million that went to Canberra 3-4 years ago, if those 3 million,
yes.
I understand.
We wouldn't have this conversation now. If those 3 million had stayed home and did BOEs on all their bills.
Yeah.
You can't go to a protest and expect a corporation to listen to you. They don't work for you. They don't have to do shit. You're wasting your time protesting against a corporation.
That's right. Like, I mean, all these protests and stuff. Like, I mean, first of all, the thing that they're protesting against is not, number one, legit anyway. 2, by voting with, like, we've just had the big election in America. People voting and thinking that they've got the illusion of choice and all that bullshit. That whole system needs bringing down. And by protesting the very system that they want to bring down, or that we want to bring down, that's not helping. If we, like you say, do the Bill of Exchange, stop paying tax, stop paying tolls.
No, you don't stop like that. You don't stop. We got to watch how we use our words. It's not stop paying. You can't pay. No one can. How can you possibly pay for something if there's no gold or silver currency to do that? The only legal tender in this country is promissory notes and bills of exchange. With bills of exchange comes with a number of different ways to discharge a debt. We can't pay anything. There's nothing to pay.
So gold and silver can't be and notes can't be a legitimate form of payment because it was taken off. It's not gold backed, or it's not backed by anything anymore. Is that correct?
If the currency in this country is pound sterling, which was removed in 1966.
Yeah.
Without a referendum. We didn't give the government of the time permission to remove our gold and silver. What they did was removed it and said, the value of our dollar, our promissory notes, will be secured by the American Greenbank. So what they've effectively done is sent us broke.
Is that
because the American Greenbank? Let me finish. Because the American Greenbank is bankrupt since 1933. So in 1966, they removed our currency that was worth something and used the Greenbank as its value, equivalent to secure it, which had been bankrupt for 30-odd years prior. So these government departments and all are operating as private pirates, profiteers, operating in bankruptcy. If you and I were bankrupt, what do you think would happen to us if they found out?
If we went bankrupt?
If we were bankrupt and we were trading in bankruptcy, what do you think would happen to you if GovCorp found out?
They'd probably try and do us for fraud.
In jail.
Yeah.
They'd throw you in prison. So how is it that these mongrels are walking free? Apparently, these rules and laws they're immune and exempt from. Now, how's that possible if it's not law? Huh? Or if it's law, sorry, if it's law they're practicing, it's not possible. But they're the ones doing exactly, carrying on day to day as normal. But when we do it, all of a sudden it's a big problem. We've got to pay for this, pay fines, go to jail, it is what it is. This is the system we're in. So back to your case though. The bill of exchange is valid. It's 100% foolproof. You just have to learn and understand it. And as I keep saying to people, don't ring me, don't email me, don't private message me over silly questions. Read the bloody bills of exchange. It's the perfect manual. Has every answer you could possibly know. And if you have to reply to a stupid letter that you receive in the mail, read their letter a couple of times to understand what is the actual focal point of their complaint in that letter. And then go through the Bills of Exchange Act, through each of the chapters, the sections. They're all got special headings. And find the heading that would relate to that particular incident. And then read it. And if it does match, copy and paste it into your own template. And then ask one question. Provide proof of claim that you, the corporation, are immune and exempt from this section. That's it. It could be an issue over delivery. It could be an issue because of expiry. It could be an issue because there was no signature. It could be an issue because they didn't understand what the bill of exchange is. It's all in that act. You just have to read it and read the definitions. Definitions tell you special words, what they are meaning, and that's what you use.
Yeah,
that's who you are.
All right. Well, let's see how Thursday goes, eh? I mean, look, I've been in court a couple of times before about other things, like trying to prove that councils don't have authority to fine us and stuff like that. And I made the mistake of, reciting off acts and things like that. When really I should have used the plan.
You know how to do the council. If you did a BOE on a council rate and you are called into court over a claim that is you did not pay, then when you turn up at court and you start waffling on about things that councils aren't legit and all this nonsense, all you've done is lose.
Yeah.
They didn't try at all. They didn't need to try. You just put your foot in your mouth and carried on like a 2-bob watch. You've got to, if their claim is that it hadn't been paid, and you did a BOE on it, then that's the only thing you need to talk about in there, because you will win. Because all you've got to do is ask them a few questions, forensic questions, that is. Did you receive the bill back in the mail with wet ink signature on it? They'll say, yes, I did. Great. Was that envelope opened? Did someone in your office, or did you, in fact, actually have a read of it? Yes, I did. Great. Then why did you not accept it? And then you sit down. Right?
Yeah, okay.
They just closed the case for you. They said, yes, 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 yes. Your Honour, I order the court to dismiss this matter because the plaintiff acknowledged receiving the bill with wet ink on it. They agreed that they received it and opened it and read it. They agreed that they did send a reply letter as a non-acceptance or non-agreement of accepting that bill of exchange endorsement, which was in fact a cheque, wasn't it, Your Honour? You see? Now, in less than a minute, I just explained the whole bloody case.
Yeah. Okay. All right. I'll. Yeah. I think I know what I'm doing. It's just a matter of keeping my composure and not getting flustered. Because the last time I was in court, I got flustered myself a little bit. I actually got thrown out of court. It was at the court in the city, and the judge said to me, "I'm not having a so-called." What did he say now? Something like a so-called lawyer, which I never said I was a lawyer. I'm just there representing myself. A so-called lawyer.
Well, you should object to that.
Law in my court, spouting common law in my court. He said.
Well, that you have to object to nonsense like that, because he gets to say that on the court record and no one rebutted it. If it's not rebutted, remember, it becomes fact. He's protecting himself when he talks nonsense like that.
Yeah.
Because he doesn't want you being right. He needs you to be wrong all the time. That's the power. That's the power they live off. That they feed off. But you just call him out. You just call out. I object to that. I never heard any such nonsense in my bloody life. When did I say I was a lawyer? See, it's just talk normal. Just call it out. Don't insult him, but be firm. You're an adult. If someone came along and some adult in a shopping line, and your kid was making a bit of ruckus, and some adult came up and just slapped your kid, what would you do?
Give him a good hiding.
Whether it's physical or not, but you would stand up for your kid, wouldn't you?
Of course. Yeah.
The funny thing is, people don't stand up for their bloody self.
No, I know.
When they hear,
I know. Like
when you hear, if you hear bullshit, get out.
Yeah, I know. Yeah, look, that is frustrating. Like you said,
courtroom. It's not a court. It's a courtroom. They like to pretend. They're pretenders. They're actors. They like to pretend they got some sort of authority. They're all narcissists, right? They're all narcissists. They're very evil. They want to harm and damage everybody, right? They get a real kick out of it. So what you got to do is just play into that. Just play into their little game, their stage play at the front, and just get into it and just say, call them out for what they're doing. If they talk badly to you, can you cease and desist with your language towards me? You're acting very oppressive. Do you have a self-interest in this matter? And then you stay quiet and expect an answer. Eh?
All right.
All right. All good?
Right. Yeah, I appreciate your time. And look, like I say, if anybody else out there has got court issues or whatever, and then people can listen and maybe they can get something from it, So
beautiful. Thank you very much. I'll do that. This will end up in LIP for everyone to watch as well.
Yeah. All right.
I appreciate that. Thank you very much.
No,
nice seeing you again, Dave.
Thanks for your time. You too, mate.
All
the best. Cheers, buddy.
Cheers, bye.
Bye-bye. Bye.